Thank you for joining, and thank you AWS for inviting me today to speak about the GDPR and IT contracts. So as Alexandra said, I'm an IT privacy lawyer based in France, and I assist my clients on privacy, digital, internet, e-commerce, cybersecurity, IT, including drafting and negotiating cloud contracts and other IT or commercial contracts. I work in both English, French, and Portuguese, and Alexandra already told you about my past. Maybe the one thing I can add is just before launching my own company, I was working at AWS as an EMEA legal counsel leading France. So I'm very happy to be here with you. And today I will present you an overview of the GDPR with the scope, main obligation, and sanctions during approximately 45 minutes. And then I will provide you some guidance regarding some clauses of IT contracts during approximately 25 minutes. The contractual clauses I will present are scope and obligations, SLAs, acceptance provision, security provision, and IP provision. Hopefully, you will leave this session with some useful contractual tips to better draft and negotiate your IT contracts, and also with a better understanding of the GDPR. Let's start now with the GDPR overview. So, GDPR. GDPR stands for General Data Protection Regulation. It's RGPD in French. We will see what is a GDPR and does it apply to you? Why is it important to comply with it? What are the risks if you do not comply? What are your obligations under the GDPR? So, what is a GDPR? Does it apply to you? The GDPR is a regulation taken at the EU level to harmonize substantially privacy legislation across EU. However, member states still have some interpretation power and the power to introduce different rules in some limited areas. It is still much better than before and substantially harmonized. The GDPR came into force on May 25th, 2018. It applies to processing of personal data, whether it is done by a freelancer or a startup or a small company or a big company. It doesn't matter as long as you process personal data. So, GDPR applies to the processing of personal data, but what is processing of personal data? There is a very wide definition of both processing and personal data. Processing is virtually every conceivable operation in relation to data. For example, access, collection, consultation, recording, organization, storage, modification, retrieval, use, disclosure, just making available, erasure. Each of them is a processing. You do any of these actions, you are processing. The individual whose personal data you are processing is called the data subject. I insist on this definition because I will be using this word a lot. So I'm going to repeat it. Data subject, when I'm going to be talking about data subject, I'm referring to the individual whose personal data you're actually processing. A data is considered as personal data if it enables to identify directly or indirectly a data subject. Indirectly means that the data will be a personal data if, when combined with other data, it enables you to identify the individual. So even if the data does not enable to identify the person directly, if when you combine it with another data, you identify the individual, it's considered as being personal data. So examples of personal data are name, email address, phone, voice, image, employment details, education and training, family and lifestyle details, IP addresses, geolocation data, device identifiers, cookie IDs, and IP addresses, all personal data. Please note also that there are some special category of data that are subject to a specific, more protective regime. Special category of personal data include in particular race, religion, health, sex life, trade union membership, political beliefs, criminal conviction, and also genetic data and biometric data. I just wanted you to be aware that all this data is subject to a more protective regime, but I will not have the time to present you this specific regime today. So, as we have just seen, the GDPR applies to the processing of personal data that are defined very broadly. Therefore, does the GDPR apply to you? The answer is very likely yes. There are still two small exceptions. GDPR does not apply to purely household activities. For example, the contact of your friends on your phone is not considered as a processing of personal data. However, the same contacts, not of your friends, but of clients on your phone, is a processing of personal data and therefore subject to the GDPR. The second exception is anonymized data. Anonymized data is not considered as personal data, and therefore the GDPR does not apply to it. The data is considered as anonymized when it is impossible to identify the data subject by any means, including with additional information, and it must be non-reversible. It is important to distinguish pseudonymous data and anonymized data. The GDPR applies to pseudonymous data, but not to anonymous data. Pseudonymous data is when you process the personal data in such a manner that the personal data can no longer be attributed to a specific data subject without the use of additional information that is kept separately. It is therefore reversible. Pseudonymous data are considered as personal data. GDPR also has a very broad geographical scope. The GDPR applies if you are established in the EU, regardless of whether the processing actually takes place in the EU or not. It also applies if you are not established in the EU, but you offer goods or services to data subjects residing in the EU, or you are not established in the EU, but you monitor data subject behaviors taking place in the EU. So, we have seen that the GDPR scope is very large and likely applies to you. But why is it important to comply with it? What are the risks of non-compliance? Non-compliance with GDPR triggers high risks. Non-compliance can lead to criminal liability. The French Criminal Code sanctions violation of the GDPR obligation by imprisonment and by fines. For example, exceeding data retention duration is sanctioned up to 5 years imprisonment and up to 300,000 euro fines. Non-compliance can also lead to civil liability. GDPR makes it considerably easier for individuals to bring claims against you for breach of the GDPR. So it means that the data subject, so as a reminder, individuals whose personal data you are processing, data subjects can sue you to receive compensation for material, but also non-material damages resulting from your GDPR breach. Data subject will be able to claim compensation for financial losses, but also, for instance, for distress and hurt feelings or damages to their reputation. Data subjects also have the right to mandate certain organizations to sue you on their behalf. And data subject can also lodge a complaint with a supervisory authority. Losing customers' trust is another risk of non-compliance with the GDPR. Data subjects will hesitate to provide their personal data to a company that does not protect it. Many small and big companies, instead of handling GDPR compliance as a constraint, a burden, or rather using compliance with GDPR as an asset, as a way to stand out from the competition. Last but not least, another non-compliance high risk are the CNIL sanctions. The CNIL is the French Data Protection Authority. So, the CNIL can provide two levels of fines, and the level will depend on the nature of the breach, on what obligation you breach. The first level is up to 10 million euros, or in the case of an undertaking, a group of company, up to 2% of the total worldwide annual turnover of the preceding financial year, whichever of the two, 10 million or 2%, is higher. The second level is up to 20 million, or again, in case of an undertaking, up to 4% of the total worldwide annual turnover, again, whichever is higher. The CNIL has sanctioned recently, again, big international and French and foreign companies. For each decision mentioned below, I will quickly mention the nature of the breach, just to give you a better sense of the risk. We will go through the GDPR obligation in more detail in part B of this presentation, so a little bit later on. On December 7th, 2020, Google was sanctioned by a 100 million fine, plus an order to be GDPR compliant within 3 months from the decision. After the 3 months, Google will have to pay 100,000 euros penalty per day of delay. The CNIL decision is public. The CNIL sanctioned Google in particular for depositing advertising cookies on the computers of the users of Google search engine without prior consent or satisfactory information. On November 18, 2020, Carrefour was sanctioned by over 3 million fine. The CNIL decision was also made public. The CNIL sanctioned Carrefour for various breaches, including users were not informed properly of the processing. Cookies, again, were deposited without data subject consent. Personal data were retained for too long. Data subjects were not able to exercise their rights effectively. Carrefour did not provide them access to their data and did not delete the data when the data subject exercised those rights. So we saw that the CNIL sanctioned big French and foreign companies, but the CNIL also sanctioned independent professional startups, middle-sized companies, and even companies with a negative financial results. For instance, Nestor SAS had a net negative impact year results since 2018. But on December 8, 2020, Nestor was still sanctioned by a 20,000 euros fine, plus an order to be GDPR compliant within 3 months. And again, if Nestor is not compliant, he will have to pay a 100 euros penalty per day of delay. And the CNIL decision is also made public in this case. The CNIL sanctioned Nestor because Nestor sent prospection emails without data subject prior consent. Nestor did not comply with its obligation to inform data subject on the processing. Nestor did not provide data subject access to their data when the data subject exercised its rights under the GDPR. And Nestor breached its security obligation by not requesting the use of a strong password when data subjects create an account. So, Before I provide you an overview of the obligation imposed by the GDPR, let's talk a little about what can trigger a CNIL investigation and how the CNIL investigates and what sanction the CNIL can issue. To give you an idea, the CNIL conducted 300 investigations in 2019. What can trigger a CNIL investigation or downgrade? Complaints of data subject. Complaints of data subjects triggered 43% of the investigation in 2019. The CNIL audit programs. Every year, the CNIL publishes an audit program. Notification of a major security breach. Information provided by the press, and information from the European data protection authorities. How does the CNIL investigate? The CNIL can conduct on-premises audits, so she can come to your facilities and audit. But the CNIL can also conduct an online audit based on the information available to the CNIL, notably via the internet, so on any public information. The CNIL can summon you to come to the CNIL premises. The CNIL can also conduct a documentary audit based on documents the CNIL asks you to provide. In any case, the CNIL has the power to obtain access to all personal data and to all information necessary for the investigation. What can happen after the CNIL investigation in case the CNIL finds a non-compliance? The CNIL can give you a warning or an order to comply, an administrative fine, as we have seen. But the CNIL can also limit temporarily or definitively your processing, can ask you to suspend the data flow, so your transfer of the data to a third country, and can make her decisions public. What are the main obligations under the GDPR? I'm sure you cannot wait to know the answer now. Your obligations depend on your qualification. Under the GDPR, you will be either a controller, either a joint controller, or a processor. You will be a controller if you determine the purposes and means of the processing of personal data. What does it mean? This means that you decide why and how the data is processed. If you determine the purposes and means of the processing not alone, but jointly with another entity, then in that case, you and the other entity will be qualified as joint controllers. If you process personal data on behalf of the controller under its instructions, then you will be qualified as a processor. So, in order to know what are your obligations under the GDPR, you will first need to assess if you are acting as a controller, a joint controller, or a processor. And to know that, you will have to ask yourself, am I deciding how and why the data is processed? You can be controller for some of your processing and processor for other processing. The qualification may be difficult in some situations, and the EDPB, so the European Data Protection Board, is currently working on some guidelines. It mentions in particular that some more practical aspects of the implementation, so the non-essential means, can be decided by the processor. So you can be a processor and still decide some of the how. Also, it is not necessary that the controller has access to the data that is being processed to be qualified as a controller. And maybe more interestingly for you, it also specified that in some circumstances, a cloud service provider, even with a standardized service offered worldwide, can still be qualified as a processor. In any case, it is important to document internally the reasoning justifying your qualification so you can explain it in case of a control. And it is important to clearly identify the roles of each parties in your contract. The CNIL will not be bound by your qualification, but it can help influence the CNIL. Now, let's go back to what do you actually need to do under the GDPR? What are your obligations? The first obligation I will present is lawfulness and fairness obligation. It applies to controllers. You can only process personal data if you can justify that you collected data subject consent for that processing, or the processing is required to perform a contract entered between you and the data subject, or the processing is required to comply with a legal obligation, or you have a legitimate interest to perform such processing, or you are protecting data subjects' vital interest or carrying out a task in the public interest. The list I just made are called the processing legal grounds, and you need to rely on one of those legal grounds. If no legal ground is applicable, then you cannot process the personal data. I will give you a little bit more details on two of these legal grounds. When you want to rely on data subject consent, you need to be able to prove that the consent was freely given, specific, informed, and express. This means, for example, you cannot collect consent through a pre-tick box. So, like when you have the box saying you consent and the box is already ticked, this is not considered as a valid consent under GDPR because you need an action from the data subject. So the box needs to be blank and the data subject needs to click on it to be an expression of consent and to fall under the consent under GDPR. In the same way, when you say when you state the use of the services means that you are accepting, no, it doesn't under GDPR. It doesn't mean consent. Also, consent provided by the data subject to various purposes at the same time will not be valid. Also, consent to the general terms and marketing, for instance, will also not be valid. Let's talk now a little bit more about the legitimate interest legal ground. So the legitimate interest legal ground requires a case-by-case analysis. To use this legal ground, you will need to balance your interest and data subject interest. You should ask yourself, can the data subject reasonably expect that its data will be processed for that specific purpose? An example of legitimate interest is video surveillance when you are doing it to ensure that the goods and individual security in your establishment. So if you want to ensure goods and individual security in your establishment via video surveillance, you can very likely do it through the legitimate interest legal ground. Let's talk now about the second obligation that I will present you, transparency and information obligation. This applies to controllers. It means that you need to inform data subject, even if you collect the data indirectly, for example, through a partner or on the internet, for instance. Every time you process personal data, you need to provide some information to the data subject regarding the processing. What information should you provide? The GDPR provides a list of informations to be provided, including, among others, identity and contact details of the controller, purposes of the processing, transfers to a third country, and the transfer legal tool used. You also have to inform data subject in case of substantial modification or a special event. Very important question. How should you inform the data subject? The information must be concise, transparent, understandable, in clear and simple terms, easily accessible, and adapted to the situation and data collection media. This is very important because the CNIL has sanctioned many companies because the information was not provided properly. There is no one-fits-all solution for proper information because, as you have seen, it has to be adapted. However, we can say in general that one block of information on the collection form is unlikely to be considered as clear. It is recommended to put forward main information and add a simple and direct access to the rest of the information. The use of new technologies is encouraged by the CNIL to adapt the information to the situation and collection media. For example, in case of IoT and technologies without a screen, you can use QR codes, vocal alerts, or SMS or email messages to provide the information. So, the information mentioned on data collection forms and the privacy policies that you see on websites, for instances, are there to comply with this information obligation. Accountability. You are responsible and must be able to demonstrate at any time compliance with all of your obligations under the GDPR. Thus, you must implement internal mechanisms and procedures to demonstrate compliance. This is the accountability obligation. This accountability obligations triggers a series of obligations, including the following. First, you must establish and maintain a written record of your processing activities. It applies to both controllers and processors. The records should include all the information listed in the GDPR, including, among others, names and contact details of the controller, purposes, recipients, transfer, data retention period, and security measures. If you have less than 250 employees, then there are some processing that you do not have to include in your record. However, the excluded processing are quite limited, and those, even if you have less than 250 employees, you will have to maintain records of processing. Accountability is also behind the obligation to appoint a data protection officer, a DPO. It applies to controllers and processors. The role of the DPO is to inform, advise, monitor, and be the interface between you and the authority and the data subject. You have the obligation to appoint a DPO if your core activities consist of processing operations which involve regular and systematic monitoring of data subject on a large scale, such as, for instance, profiling, geolocalization by mobile app, marketing based on behaviors. The second case is if your core activities consist of processing on a large scale of special categories of data. You can appoint a DPO internal to your company, an employee, or an external one, for example, a privacy lawyer. You will also have the obligation to carry out a privacy impact assessment. This is often called PIA. You have the obligation to conduct a PIA when the processing is likely to result in a high risk to the rights of the individuals. It applies to controllers. For example, if you want to implement automated processing, assessing a job application, and that could lead to a rejection of the application without any human intervention, you will need a PIA. Another example, you want to collect geolocalization data of a large number of individuals to create marketing profiles and to provide them personalized ads depending on their location, travel, then again, you will need a PIA before being able to process such data. So what is your PIA? During your PIA, what you will do is you will assess the necessity and proportionality of the processing operation in relation to the purposes of the processing, and assess the risk to the rights of the data subject, and define and assess the measures envisaged to address the risks. PIA has to be communicated to the CNIL if after the evaluation, the residual risk is high. This is referred to as the prior consultation. Accountability also requires you to implement internal data protection policies, internal training, and draft and keep up to date the relevant documentation. Let's talk now about another very important obligation under GDPR, security. Security obligation applies to controllers and processors. You must implement appropriate measures to ensure a level of security appropriate to the risk for the rights of the individuals. You will take into account for that the state of the art, the cost of implementation, and the nature, scope, context, and purposes of the processing, as well as the risk for the individual. So there is not like a list of security obligations that will be sufficient for any processing. It's again a case-by-case analysis. You should implement usually physical, organizational, and technical measures. You should approach security from the following three aspects: confidentiality, integrity, availability. And you should consider source risk coming from inside and outside the company, from a voluntary or involuntary action or inaction, a breakdown or incident. You can find very useful security guidelines in the INC and CNIL guidelines that I mentioned in this slide. They are available online for free in both French and English. Also, the GDPR provides some examples of security measures, for instance, pseudonymization and encryption of personal data, process for regular testing, assessing, and evaluating the effectiveness of security measures. And other examples are authenticating users, strong and regularly changed passwords, antivirus and software updates, secure access to premises, separate user profiles to access data, training and awareness raising sessions on information security, confidentiality agreement with users or specific confidentiality clauses in the employment contracts, implement IT policies, supervise data security with subcontractors, including in your contract with them. But what should you do when you have a security breach? Hopefully it will never happen to you, but if it happens, you must act very quickly. So it is important to be prepared and have the right processes in place. The first thing you must do is you must determine if the breach of the security leads to the destruction, loss, alteration, or unauthorized disclosure of or access to the personal data. If the answer is no, then woohoo, yippee, you do not need to notify it. But if the answer is yes, then you may have to notify the breach to the Data Protection Authority, and in some cases also to the data subjects. First, let's talk about breach notification to the data protection authorities. You need to notify if the security breach results in risks for rights and freedom of individuals. Be careful, because the delay to notify is very, very short. You need to notify without undue delay and, where feasible, within 72 hours after becoming aware of it. So it means that you need to notify within the 72 hours, but because you need to provide some mandatory information in your notification, it means that you need to have collected a big part of this information and to be able to do the notification within the 72 hours. The information you need to include is listed in the GDPR. If you do not have all the information at the beginning, you can still make the notification and then provide the rest of the notification without undue delay, but you still need to have some ready. You must document the security breach, including facts relating to the breach, its effects, and remedial actions. It is thus really recommended to implement internal policies, process to manage security breach, to guide you in the event of a breach. You don't want to be lost when you have your breach and say, I don't know what I have to do. And you need to have this at least very high level policy to guide you and to know exactly what you have to do. Also, it is important to include the appropriate provision in your contract with your subcontractors to ensure that they will notify you on time and assist you as necessary. When your security breach is likely to result in a high risk to individuals, then you must also notify the data subject. This notification must be done without undue delay. Again, you must provide in the notification the information that is listed by the GDPR. It must be provided in clear and plain language. You can avoid this notification if appropriate protection measures were applied to the personal data concerned, in particular to render it unintelligible to non-authorized persons. So, for example, it was encrypted, or subsequent measures were taken to ensure that the high risk to the individual is no longer likely to materialize. For example, passwords were stolen to access the database, but before they were used, passwords have been reset. Or it would involve disproportionate effort, but in that case, you will still need to make a public communication or take similar measures whereby the data subjects are informed in an equally effective manner. Let's talk now about data subject rights. GDPR wants data subjects to retain control over their data, and therefore data subjects have different rights under the GDPR when you process their personal data. This is also something that is often sanctioned by the CNIL. And it's also one thing that could trigger complaints to the CNIL. And as we have seen, complaints to the CNIL can trigger control. So they are very important. It's very important for you to understand them and to try to comply with it. You must provide data subject an easy, clear, and efficient procedure way to exercise their rights before you. When data subject exercise their rights before you, you must answer within 1 month. I will not have the time to present you all of the data subject rights, but I will present you the more frequent, important ones. Data subject have an access right. Data subject have the right to know if you process its personal data and to obtain from you a copy of its personal data in an understandable format. You will have to provide the copy of the data processed, even if they request it, and also some mandatory information listed in the GDPR. Data subject also have the right to rectify the personal data you are processing. Data subject have also the right to object to your processing of its personal data. At any time, data subject can make you stop processing its personal data for marketing purposes without needing to justify its request. You cannot reject such requests and must stop using its personal data for marketing. If a data subject asks you to stop using their data for marketing, just stop. There is no way to stop this request. However, when you are not processing its personal data for marketing purposes, but for other purposes, then In that case, data subject objection right is more limited, and you may be able to reject data subject in some circumstances. Still be careful, but you may have some arguments to reject it. Data subject have also the right to be forgotten. The right to be forgotten is a right for data subject to force you to delete its personal data. It is not an absolute right. Data subject can only exercise its right to be forgotten in some listed circumstances, and you may be able to reject data subject requests in some circumstances too. Data subject also have a portability right in some circumstances. Again, it's not an absolute right. It is the right for the data subject to receive their personal data in a structured, commonly used, and machine-readable format, and have the right to transmit those data to another controller, so mostly to a competitor, without any hindrance. Data subject can ask you to transfer it to the new controller, to your competitor, if this is technically possible. You must communicate any rectification or erasure of personal data carried out upon data subject request to each recipient to whom you disclose the personal data. You do not have to do it if you can prove that it is impossible or involves disproportionate efforts. If you process as a processor, you should process the personal data on controllers' documented instructions. As we saw before, if you are the provider of a B2B service, you may still be a processor for the data processed in your service. A SaaS provider can be a processor. GDPR provides a list of mandatory provisions to be included in the contract between the controller and the processor. This contract is called a Data Processing Agreement, a DPA. The processor has the obligation to assist the controller to comply with data subject rights and to comply with its security obligation, PIA, and prior consultation. The processor has the obligation to assist the controller to comply with controller's security obligation, but the processor also has the same obligation than the controller to implement technical and organizational security measures. Processors must provide an audit right to controllers, and processors must delete or return all personal data and delete existing copies. Processors cannot subcontract data processing without controllers' written and prior consent. Processor must also ensure that persons authorized to process the personal data have committed themselves to confidentiality. Therefore, you should carefully draft provisions to determine the extent, modalities of such assistance to controller, security obligation, audit rights, sub-processing, and deletion of the data in your DPA. Transfers outside the EU. The rule is you cannot transfer personal data outside the EU except if you can prove that you are covered by one of the exceptions provided by the GDPR. What are those exceptions? The first one, European Commission adequacy decision. For instance, Japan, Switzerland, Argentina are covered by the adequacy decision. Therefore, you can transfer to those countries personal data. On February 19th, the European Commission published a draft adequacy decision also for transfer to the UK. And this is the beginning of the process towards the adoption, but if it is adopted, then you will be able to transfer to the UK also very easily. The second key exceptions are appropriate safeguards. The main ones are the standard contractual clauses, what we call SCCs. They are adopted by the European Commission or the data protection authorities. Basically, it's a document with different contractual provision. And if you include those provisions in your contract with an entity located outside the EU, then you can transfer to that entity located outside the EU. But you must not change those provisions. They must be really incorporated as is. There are also binding corporate rules. I won't talk a lot about it because they are only used within a group of companies to enable the transfer outside the EU between the entities of the same group. The European Court of Justice decisions Schweinswand and Schrems II complexified reliance on SCCs and BCRs, complexifying, therefore, the transfers outside the EU. We are going to talk about this in the next slide. Before that, let me mention briefly the third exception that you can use to transfer outside the EU. The third exception is derogation for a specific situation. However, be very, very careful because this is limited. This is very strictly interpreted, and the authorities clearly stated that it should remain an exception and you should not use it as a rule for transferring outside the EU. It cannot become the rule. It really should stay very limited in its use. Let's talk now about the Schweinswand and Schrems II decision of the European Court of Justice. Before such decision, there was another appropriate safeguards to transfer to the US. You could transfer data to the US based on the privacy shield, and before that, on the safe harbor. This is not anymore an option. They have both been invalidated by Schweinswand for the safe harbor and Schrems II for the privacy shield. So privacy shield and safe harbor are now invalidated. You cannot use it to transfer to the US. The SCCs and BCRs have also been impacted by this European Court of Justice decision, Schrems II. They are not invalidated, and you can still transfer to any country outside the outside the EU, including the US, based on SCC and BCR. You can still use it. However, before the decision, when you are using SCCs or BCRs, you knew that your transfer would be compliant. Now, with this decision, using SCCs or BCR will not be sufficient to ensure that your transfer outside the EU complies with the GDPR. You must assess that the law of the country outside the EU, where you are transferring the personal data, does not impinge on the adequate level of protection provided by the SCCs. If you consider that this might be the case, then you should implement supplementary measures and assess if the SCCs, along with the supplementary measures and taking into account the circumstances of the transfer, will ensure that the law of the country outside the EU does not impinge anymore on the adequate level of protection. If there is no impingement, then you can transfer. Otherwise, you cannot and need to rely either on another exception or notify your decision to still transfer to the Data Protection Authority. Very quickly, some examples of supplementary measures. It can be technical, for example, encryption under strict condition, organizational, internal policies, legal, annexed with information provided by the importer on its local law, obligation to take specific measures. There are other obligations under the GDPR. I listed here on this slide some other key ones. First, you can only collect personal data for specific, explicit, and legitimate purpose, and you can only process the data in a manner that is compatible with those principles. Data minimization obligations. This means that you must only process personal data that is adequate, relevant, and limited to what is necessary in light of the purposes. It is, for instance, recommended when it makes sense in practice to rather provide a scrolling menu to your employees instead of free command zone to avoid collecting unnecessary personal data. Under data minimization principle, before launching a new processing, you should ask yourself, is there a less intrusive way to do it? You must also ensure that the personal data is accurate and, where necessary, kept up to date. you must take every reasonable step to ensure that personal data that are inaccurate having regards to the purpose for which they are processed are erased or rectified without delay. Also, you cannot store or otherwise process personal data for an unlimited period of time. You need to determine for each processing what would be the appropriate retention period. The CNIL provides some recommendations. For example, 3 years for prospect data as from the last contact from the prospect or time of collection. Another obligation under the GDPR is to implement data protection by design and by default. This means that when you are thinking of a new service or project, including processing of personal data, you must already take into account the GDPR principles and implement the appropriate measures. And it also means that you must implement measures for ensuring that by default, only personal data which are necessary are processed. So you need to have the GDPR in mind at all steps, from the thinking of a project to the design of a project to the actual implementation of the project. There are specific rules for marketing and cookies. This rule results from a combined lecture of the GDPR, e-privacy directive, French transposition of the GDPR, and the French electronic communication and French code and French consumer code. I really do not have time here to present them today, but I wanted at least to draw your attention that they are subject to specific rules. Be careful with cookies and marketing. Specifically, in particular, cookies have been subject to new requirements recently, and I see a lot of old banners. They may not be compliant anymore, and you have until end of March to actually apply the new requirements. So now, hopefully, you know at least a bit more about GDPR. We will now talk about IT contracts. So this presentation will be much shorter than the GDPR overview. IT contracts are contracts related to technologies and cover very different contracts. It includes cloud contracts such as SaaS, IaaS, PaaS, but also licenses, maintenance, development, consulting, support, training, ITO, BPO, integration, partnerships, terms and conditions, and terms of use of a website or an app. They all are considered as IT contracts. Why is it important to have a well-drafted contract? It is highly recommended to have a well-drafted contract for different reasons. A clear contract will provide both parties a clear understanding and foreseeability on the scope, nature, and modalities of the service or deliverables provided, and each party obligation. This reassures both parties and also avoid friction with customer during the performance of the contract regarding, in particular, whether the provider complied with its obligation or not. It's better to have it clear so everyone knows. A well-drafted contract will also enable the provider to protect its P&L, so its margin, and it also enables the provider to manage its liability risk. Do not forget that without a contract, there is no liability cap at all or exclusion applicable, and the provider will have to compensate customers for 100% of the direct damages suffered by its customers. A well-drafted contract is also required to comply with specific regulation, as we have seen, for example, to comply with the GDPR, but also to comply with financial service regulation and to consumer law. A well-drafted contract will enable both parties to also protect, transfer their assets and IP. There is no one-fit-all IT contract template. There are very different types of IT contracts, and an IT contract needs to be adjusted to the deliverables or services provided, to the potentiality and level of risk, to the business of the parties, to the business and financial model of the service provider, and to all specific regulations that may be applicable. And those are just some of the elements that need to be taken into account. For example, a reversibility provision or an acceptance provision will not be included in all IT contracts, even when the same clause is in two different contracts. It will not have the same importance and not the same content. For instance, when negotiating a development contract, IP clauses and acceptance provision may be very important to you, whereas in a cloud contract, you will be much more focused on access to data, availability, and security clauses. I will not present you all key contractual provisions or go into details. I won't have the time to do that, but I will try to provide you some contractual tips regarding some clauses in the IT contracts. Let's first start with some very important provisions, the scope and obligation provisions. Depending on the contract, scope and obligations provision will be in different clauses, documents, and drafted very differently with more or less details. For example, it can be in a statement of work attached to the contract or in a service description document that you may attach to the document or have a link online to that document. The scope and obligations may also be partially described in a specification document, or they can be included in specific clauses of the contract under the name of obligation or object of the contract. It will really depend on the contract, but it will have different impacts. Those provisions are very important because they will describe what the provider is committing to do for the price paid by the customer. So thanks to that provision, the customer will know what they get for the price paid, and the provider will know if it is breaching the contract or if it has fulfilled its obligation. With a well-drafted contract, the provider commits to provide all that is described in the contract, but only this. So it's very clear for both parties. You should verify that the scope and obligation provisions are clear, exhaustive, and understandable by a person with no IT or engineer background, for example, a judge. So try to use plain language. Also, the provider may establish its pricing based on a certain number of assumptions. And if the assumptions are incorrect or changes in the course of the contract, then provider's P&L margin may be affected, except if the provider has included such assumption in the contract. For instance, provider's price may be based on a maximum number of users or a minimum consumption amount. Those assumptions should be included in the contract so the provider can protect its P&L. The provider may also need to provide its services that the customer comply with some rules, cooperates, or provide some elements such as point of contact, relevant information, or access, or tools. It is important for a provider to include such dependencies in the contract to ensure that the provider will not be liable for damages that actually results from the customer's non-cooperation or non-compliance with such rules and obligations. Depending on the services, and in particular for customized services such as ITO, BPO, customers may want to include a fixed calendar to complete main milestone associated with a penalty, and also they might try to include sweep clauses, which are very broad sentences to extend providers' obligation services above what is expressly provided in the contract. The provider may then have to provide services that the provider had not expressly included in the contract and have not anticipated and have not thus been included in its pricing. And those having to do it may decrease its P&L. So if you are the provider, watch out for such sweep clauses, for such broad sentences included in the contract or description of the services that will actually broaden what you have to do. Also, this provision, so the scope and obligation provision, will enable you, for the parties, to define the nature of the provider's obligation. Has the provider a result obligation, or a best efforts obligation, or a commercially reasonable effort obligations? This will depend on the wording used in the contract, but will have an important impact on providers' liability. Scope obligations provisions are very specific in standard cloud services, SaaS, IaaS, PaaS, when the provider provides the same cloud solution to all its customers. Let's talk a little bit more about this. The provider wants and needs, it's very legit, to retain the flexibility and agility required to improve its solution and innovate, and to modify its solution to adjust to the quick evolution of technologies and market. Those in such contracts, providers' position will be to draft the scope obligation provision in a way to retain flexibility and to be able to change the services unilaterally quickly. The description of the services will, for example, be online on their website, and the provider will be able to change unilaterally this description of the services to reflect the changes made to its services. The customers want the provider to improve the services. That's why they are taking this solution. Often they want an innovative, disruptive solution. So they need to provide such flexibility and agility to the provider. However, they are at the same time very scared of unilateral changes that could be detrimental to the way they are using the services, or to the internal value, or to their internal values or policies. They want to control changes and ensure that key services and functionality remains. Their position is often strengthened by the fact that having a provider that can change unilaterally their services is really not what is usually done. They have been used to draft contracts where they retain the control. And also, their position is also often strengthened by the fact that changing provider may take some time, money, and disrupt their activity. So they have all these concerns. How do you reconcile these two positions? How can you provide the necessary required flexibility to providers, and at the same time provide some control and reassurance to the customers? Different solutions are possible. Again, there is not a one-fit-all position, but you can choose. I will present you different mechanisms that you can use. The mechanism will have to be chosen and adjusted depending on various criteria, such as the duration of the contract, the duration of the services, the negotiation power of each party, how the use of the services actually impacts customer own activity, how easy it is for the customer to move to another solution if needed, etc. Here are some examples of contractual mechanisms that can help reconcile providers and customers' position. One mechanism is to provide that the provider can change unilaterally its services, but will have to notify customer of the changes before the changes are implemented, and provide the customer with the rights to terminate the contract if they are not happy with the changes before it is implemented. This solution can be adjusted by limiting notification to material changes or to discontinuation of a service or functionality. Another mechanism that can be used is to provide that the provider can change unilaterally its services as long as the changes improve existing services and customer can still use all the services and functionalities that are available at the date of the contract signature. A third mechanism can be identifying some key features for the customer and having a commitment of the provider to always maintain the key features. Provider can change how they provide it as long as they don't discontinue such features. Let's talk now about service level agreements. This provision is related to the provision we just mentioned in our last slide, because SLAs will define providers' obligation regarding notably availability, continuity. SLAs enable to define and control the quality of the service and will be crucial to determine whether there is a breach or not. SLAs are usually defined in an appendix to the contract and can be the center of intense negotiation in some contracts. For cloud services, it might be online. In your SLA, you will define the quality of the service provider's obligation by using KPIs. It is important to use clear, objective, appropriate, measurable KPIs. Make sure you can actually calculate the SLA, otherwise there is no point in having it. You need to be able to calculate it and verify that there is no doubt on how it is calculated for both parties. The provider will have to regularly measure the KPI and provide regular reports during the life of the contract. Usually, the parties decide to include SLA credits. SLA credits are the amount of money that the provider will owe to the customer if it does not meet the SLA. Credits should be defined clearly. They are usually defined as a percentage of the amount paid by the customer. Providers may want to cap the SLA credit. Customer will try to impose that the SLA credits are due on top of any damage that may be due under the liability provision for such a breach. Provider will provide that, on the contrary, the SLA credit is the full and sole compensation for the customer that the customer will be entitled to for breach of the SLA. Providers may also want to include earnbacks provision to the provider to earn back its SLA credits if it overperformed during a certain amount of time, for instance. Standard cloud services need for flexibility may also impact the SLA, and providers may want to have an online SLA that it can change from time to time to adjust to the evolution of the services and the technology. Again, customer may oppose to that. You can find a balance between both positions using the same type of mechanism described in the previous slide. Let's talk about deliverable acceptance now. This provision will describe the criteria, test, procedure that will follow the customer to accept or reject a deliverable. This is an important provision, as often payment will be retained in all or in parts until the customer fully accepts all deliverables or service. Depending on the contract, it will not always be appropriate to include an acceptance procedure provision, and the content of this provision may also vary a lot. For instance, you will usually include an acceptance procedure for specific developments, but conversely, this provision may likely not be appropriate for standard solutions such as a SaaS service. An acceptance clause need to include a clear, precisely defined and objective conformity referential and clear timeline. It should be also specified if the acceptance can be tacit or has to be expressed, and what anomalies will give the right to the customer to not accept the services or deliverable. The provision should also describe the consequences of non-acceptance of a service or deliverable. This includes, for instance, describing that the provider will have to correct the anomalies within 5 days and then resubmit it to the acceptance procedure. You should also describe in this provision if the customer can retain all payments in case of acceptance of only part of the services or deliverable. Let's talk about the security provision now. Again, this provision will not be appropriate in all contracts and will not be drafted in the same way depending on the contract. For instance, this provision may not be appropriate in a development contract or a consulting contract. However, it would be a very important provision in a cloud contract. Also, very different specific regulation may impact this provision. For instance, the GDPR, as we discussed it before, but also financial services regulation. Depending on the contract, you may find this provision as a security provision or as an appendix attached to the contract or as an online document. The level of security and security obligation and providers' flexibility regarding security vary a lot from one contract to another. It is recommended to include in the security provision a description of the security obligations of the provider, but depending on how this provision is drafted, the provider will have more or less flexibility and the customer will have more or less guarantees regarding the level of security. There are very different ways to describe the security obligations. You can use general wording, just referring to a certain level of security and or best practices. This provides flexibility, but a certainty for both parties on what will be considered as a breach of provider's obligation. You can be more specific, and the provider will be obliged to implement the measures that are actually described in an appendix, for instance. The provider has less flexibility, but this provides more foreseeability and guarantees to both parties on what actually the provider has to do and what would be considered as a breach of its security obligations. You can also decide to not describe measures, but instead to refer to security-specific standards or certifications. For example, provider can commit to be and remain ISO XXI certified or PCI DSS certified. You can also add more flexibility to a provision by adding a wording such as the provider commits to provide at least the same level of security than. If the provider provides an audit right to its customer, then the modalities, costs, frequencies, and consequences of such audit should be carefully drafted and included in the security provision. Should also be described in B2B IT contracts the cooperation between the party in case of security breach notification. So in case of security breach for the security notification obligation under the GDPR. For some services, such as cloud, the customer should also check if the provider has in place a disaster recovery plan and a business continuity plan. Such plans may or may not be attached to the contract. In cloud contracts, the security provision may be subject to quite intense negotiation between the provider and the customer. The provider needing to take into account the standards, multi-tenant, evolutive nature of its services, and the evolution of security standard practices and threats. The customer will have in mind the potential high risk for its contents and the needs to have security commitments compliant with the applicable specific regulation. I am going over the time I was allocated for. This is the last clauses I'm going to present you, but since I really want you to have this Q&A, I will go more quickly on this one than I anticipated. What you need to know about IP is, again, it's not the same. It will not be drafted the same way in all the contract, and it doesn't have the same importance for every contract. In a development contract, it will be very important and highly negotiated, where our professional services, it may be the same, whereas in a standard cloud contract, usually it's not the IP provision that triggers a lot of negotiation. What you need to know is there is no automatic or implicit transfer of IP rights except in very specific limited exceptions. So even if you do a contract specifically to develop with another company to develop software or a work, whatever work it is that has IP rights on it, then the IP rights will not be transferred to you if you do not have an IP provision in your contract. When you draft your IP provision, what you need to be careful about is because you will only transfer what is written in your contract, you need to be very specific on what you actually are transferring. So you need to specify the geographic scope, the duration, the right transferred, and also whether or not you provide an exclusivity and the fees. And the right transfer has to be explained because you may not transfer all the rights on your IP. You can transfer only access or the right to modify or copy. Now I have finished my presentation on GDPR and IT contracts. I hope it has been helpful to you. Thank you for listening, for listening to me. And now I'm very happy to take your question and to engage in a discussion with you on any question you